Advisory counsel is here. Mr. Wagner, are you appearing before the state?
Yes.
This is the time set for sentencing. Good.
Excuse me, how you doing?
No, I'm talking now.
Okay.
Listen to me. Is your true name and your complete name Shayna Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22.
The way this starts tells you everything. She's not here to cooperate. She's here to fight the system itself. But court isn't a debate club. The judge isn't asking for a philosophy lesson. He's trying to sentence someone after a jury already said guilty. And when someone keeps talking over the process, the court doesn't lose jurisdiction. It just hinted that today is going to end the hard way.
Mr. Wagner, do you want to be heard on behalf of the state?
I do, Your Honor.
I refuse to proceed.
And if the victims wish to be heard, we have victims here in the courtroom. A victim, I think. I'm not sure.
No, Your Honor. She's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
Right, so y'all can't do that. Y'all cannot force me. Y'all can't sentence me like this.
Ms. Blackshire,
This part hit me. The victims aren't even here, not because they don't care, because the case got dragged so long they had to go back home. That's the hidden damage people forget. Even when nothing graphic happens, the stress follows victims for months or years. And you can hear the prosecutor's frustration. It's like, we're still doing this, because you wouldn't stop turning it into chaos.
the 208, Your Honor. She was taken into custody for 208. She made bond and was released on bond, and then she committed these separate offenses while on felony pretrial release.
I just want to make clear, to save your words, I do intend to impose the enhancement of 2 years for the crimes being committed while on release. So I just want to...
All right, thank you.
If there was any confusion about that, I wanted to straighten it out. I apologize for interrupting you, but I thought it was...
Here's the key legal piece in plain English. If you're out on bond or release and you commit new crimes, the law can add extra time. That's not the judge being petty. It's basically the system saying, we gave you freedom while your case was pending, then you used it to do more harm.
Count 4, Your Honor. The defendant confronted the victim at her home and has substantially affected the way the victim feels about her safety and security at the home, which I think is very important, Your Honor, to acknowledge that.
I'm sorry. I'm getting... What's that?
Are you going to allow
No, I'm talking to you. Why are you taking her up? You're not? Okay.
Because I don't want to be in here.
Staying in.
Requested to leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
That's fine, Your Honor.
I was getting signals from the defense.
That's fine. I also would point out to the court that the unlawful flight from law enforcement...
All right, stand by. Apparently they're going to restrain her and bring her back in.
Refamiliarize me in the email about what that is.
When the prosecutor talks about safety and security, that's not a dramatic line. That's real. A home is supposed to be the one place you can breathe. If someone confronts you there, it changes how you sleep, how you check your doors, how you live. And then the outburst happens. And honestly, that's the moment the court stops being patient and starts being procedural. Because when you won't follow basic rules, you don't control what happens next.
To watch, I suppose.
Very well. Thank you very much. All right, the court imposes a sentence as follows. As to count 1, unlawful flight, a Class 5 felony, the court, as I said, finds the offense to be non-repetitive, non-dangerous. The court imposes the presumptive term of 1.5 years in the Arizona Department of Corrections. The court imposes an additional 2 years sentencing enhancement because this offense was committed while the defendant was on pretrial release. and that's pursuant to ARS 13708D. So the total sentence as to count 1, Class 5 felony, is 3.5 years. As to count 2, this is the misdemeanor criminal damage. The court imposes a sentence of time served. As to count 4, again, the court finds this to be non-dangerous and non-repetitive. This is burglary in the second degree, Class 3 felony. The court imposes the presumptive term of 3.5 years. This court also imposes the sentencing enhancement pursuant to 13708D of 2 years. So the total offense level, the total sentence for count 4 is 5.5 years. As to count 5, resisting arrest, it's a Class 6 felony, non-dangerous, non-repetitive. The court imposes the presumptive sentence of 1 year. The court further imposes the sentencing enhancement as required by law under ARS 13708D for 2 years, for a total of 3 years as to count 5. The court further designates that the sentence imposed on counts 1 and 5 are to run concurrent with each other. That is the unlawful flight and the resisting arrest. The sentences in counts 1 and 5 are to run concurrent with each other. The sentence imposed on counts 1 and 5 are to run consecutive to the sentence imposed on count 4, which was 5.5 years as to burglary in the second degree. So the sentence imposed on counts 1 and 5 is to run consecutive to count 4. The court imposes the sentence imposed on count 4 in this case, which is burglary in the second degree of 5.5 years, is to run consecutive to the sentence that was imposed in case number CR 22208. Right, so the sentence imposed as to count 4 in this particular case is to run consecutive to the sentence imposed in case number CR 22208. That's because this defendant was released in the prior case, 22208, when it was a justice court case. She was released when she posted bond on July 7th, 2021. She failed to appear and a warrant was issued for her arrest on October 20th, 2021. The events in this particular case are alleged to have occurred, I believe, on February 5th, 2022. So the events that happened at the Morningstar Ranch that were the subject of 22208 are alleged to have occurred on the dates those were alleged to have occurred back on June 12th, 2021. So the prior case, the burglary, alleged to have occurred on June 12, 2021. The fraudulent schemes in 22208 was alleged to have occurred on or about July 6th. She was found guilty of that by the jury. So she was charged with that case, released, went out and committed basically.
This sentencing is heavy, but listen closely. The judge isn't just throwing numbers. He's stacking consequences. Concurrent means some time overlaps. Consecutive means it stacks back to back. And the enhancements add years because of the while-on-release factor. The message is simple. You don't get to keep cycling through the same property, the same people, the same pattern, while the court is already dealing with you.
Days of the sentence imposed. Did you wish to, well, I'm not going to ask you whether you wish to address the court. You've clearly indicated you're not capable of doing that and following the rules of the court. You have the right to appeal the judgment of the court. If you wish to appeal, you must file a written notice of your intent to appeal, and you must do that within 15 days of today's date. Otherwise, you will lose that right. Ms. Blackshear, do you wish the court to appoint an attorney to represent you on the appeal? No, he will not be representing you on the appeal. Do you wish to have an attorney appointed to represent you on the appeal? If you cannot afford to pay one, the court will pay the cost of an attorney to represent you on appeal. That will include the cost of the lawyer's legal fees and legal costs. You will not have to pay anything. Do you wish to have an attorney appointed to represent you on the appeal? No. Appeals are specialized actions, and Court of Appeals is very sticky with their rules. They're very strict, and this is a real specialty with someone who knows how to write good appeals. I met with you before when you were here before, and we met in not in chambers, but in the holding cell area. It's all on the record, what I'm referring to, and I advised you that it really is in your best interest, I believe, to have a lawyer represent you on appeal, and you indicated at that time that you don't want a lawyer to represent you on appeal. I'd really encourage you to do it. I think it's in your best interest, but it's your choice. Okay.
You said I need what with that?
You're excused. You're remanded to the custody of the sheriff to be delivered to the Arizona Department of Corrections to fulfill a sentence.
How much time?
Hold on a second. What?
How much time did he give me? You just said a whole bunch of numbers.
Yeah, you can take them. You're excused. Thank you. Good luck. All right. I'm not having the defendant step forward to sign for notification of her rights and to sign the judgment in this particular case.
The judge's tone here is brutal, but it's not random. He's saying, you have rights, appeal, attorney, deadlines, but rights still come with rules. If you refuse to cooperate with every step, you end up isolated inside the process you claim you don't recognize. And that's the tragedy. The system becomes a wall the moment you treat it like an enemy instead of a reality.